ladies and gentlemen, you have a man who was driving a motorcycle irresponsibly, caused an accident, and now wants to shift the blame to someone else. You have a man in Mr. Drueck who wants to avoid taking responsibility for his actions. But that's not what our law permits. The law says that if Mr. Drueck was negligent, then he cannot recover from Mr. Morris. The only way he can recover from Mr. Morris was if Mr. Morris intended to hurt him, Mr. Morris acted recklessly, with gross negligence, or with willful and wanton misconduct. And putting tree limbs by the curbside does not fall into those categories. The evidence shows that Mr. Drueck was negligent. It shows that even if Mr. Morris was negligent, he was not guilty of gross negligence. And for that reason, Mr. Drueck cannot recover from Mr. Morris. Now, you've heard a lot of testimony today. You've heard from people who live on this street. The case ultimately boils down to one issue, and that's who's at fault in this accident. Now, I want to talk about the testimony that's conflicting. We have this question of whether Mr. Drueck could stop in time for the branch. Was he speeding? The truth is, how fast Mr. Drueck is going really, the exact speed really doesn't make a difference. If he was traveling slowly, he should have been able to stop. Yep. We all find things in the road when we're driving. It's just something we have to be ready for. But we don't go on accusing someone of reckless conduct just because there's something in the road, especially something like a tree limb. The wreck itself should serve as evidence that Mr. Drueck was going too fast. And we have a rule called the assured clear distance rule. And it says that Mr. Drueck could not have been able to stop with a tree limb and he was negligent. And suppose Mr. Drueck could have stopped with a tree limb and he wrecked. He's still negligent, isn't he? So whether he could stop or couldn't have stopped, he's still negligent, according to the law. Then we have this question of how far the tree was sticking out into the road. And we have conflicting accounts on that. But whether the tree stuck out into the road 16 feet or 1 foot, it shouldn't make a difference. If the tree stuck out into the road 1 foot, then Mr. Morris was not obstructing traffic. But if it stuck out 16 feet across the middle of the road, then Mr. Drueck should have been able to see it. Ms. Wheeler's testimony established that a person on the east end of Shadow Bend can see a tree if it's extending past the middle of the road. So however Mr. Morris set the tree down, he didn't set it down in a manner that was negligent towards Mr. Drueck. Then we have this question of what Mr. Drueck did when he reached the tree. Mr. Drueck claims that he tried to go around the tree. Mr. Morris says that he headed straight at the tree. Who should we believe? We should believe the person whose testimony is corroborated. And we have one other witness who saw what Mr. Drueck did when he reached the tree. Billy Jorgensen told you that Mr. Drueck headed right at the tree. It was Mr. Morris's testimony that was corroborated. And the weight of the evidence here shows that Mr. Drueck did not try to go around the tree, but headed straight at the tree. And the weight of the evidence of this whole case shows that Mr. Drueck was negligent, that Mr. Morris was not at fault. So I ask that you find Mr. Morris not liable.